How does the world of two chicken-loving, food-providing businesses located across two different continents with a massive ranging ocean between them collide? This is Decoding Law with upGrad. In this episode, we are going to decode one of the most mouth-watering IP law cases of the last couple of decades. But before we move forward, let's rewind all the way back to the 19th century. Industrialization has peaked. Cities the way we know cities today are beginning to take shape, and trade between countries and continents are now increasingly common. Countries are now dependent on economies, which in turn are dependent on industrial produce. The higher the trade and manufacturing power of a nation-state, the more chances of its unending prosperity. All of which is well and good, but how do you then motivate a population of people to do more? With so much emphasis on growth rates and production, how does one find newer ways to stand out financially in a brave new industrialized world? Well, some leaders in Paris had an idea. On 20th March 1883, the government of France, along with 11 other countries, introduced the Paris Convention for the Protection of Industrial Property, widely regarded as one of the first treaties towards an idea of intellectual property rights. By providing people with the opportunity to claim ownership of an idea or an invention, leaders at the time believed that it would help promote the creation of newer, creative, and original work that would eventually fuel economic growth. Did it work? Well, it's nearly 140 years since that was signed, and the treaty is still in effect. So, you tell me. Now let's talk about the two protagonists who have given us the most mouth-watering case of the decade, Mr. P.S. Nandakumar and Mr. Fernando Duarte. In 1963, Mr. P.S. Nandakumar noticed something about newly independent India. He realized that we as people were looking ahead and thinking future first. Eventually, he struck upon an idea that turned him into one of independent India's first successful entrepreneurs with a business that continues to thrive even in 2022. Large-scale poultry farming and aiding in the wholesale distribution of chicken and eggs. A young nation, after all, needed its proteins, and Nandos promised to provide it. Around 25 years later, Mr. Fernando Duarte visited Chickenland, a Mozambican restaurant at the heart of Johannesburg, South Africa. He decided to order one of their chicken meals, but sprayed some of the exotic peri-peri sauce he had on him all over his food. One thing led to another, and Duarte began a chain of restaurants dedicated to his holy combination of chicken and peri-peri sauce. He named it Nandos, after his firstborn son. So now we know exactly how these two chicken-loving, food-providing businesses, located across two different continents with a massive ranging ocean between them, collide. Expansion, of course. Since that little discovery Mr. Duarte made at Chickenland, Nandos grew exponentially. It quickly became one of the world's biggest food chains, competing with the likes of McDonald's and Subway. An entry into India seemed inevitable. With a massive potential market and with one of the largest non-vegetarian populations in the world, the people of Nandos licked their lips at the opportunity in front of them. It was in 2006 when they officially entered India. Nandos did a soft launch, opening 3 restaurants in Mumbai. They were well on their way to taking whatever it was their next step was, until something rather odd happened in 2007. Nandos believed that Nandos was using the similarity in their name to sell their products. In short, they believed that Nandos worked so that Nandos could run. It wasn't just that Nandos believed that Nandos were jumping off from their already established success in the country, but they were using certain signs and images that were also very similar. Despite the court pointing out that the service provided was different, Nandos was a restaurant chain, while Nandos provided frozen meat. The good people of Nandos claimed that they did have plans to open snack bars someday. They used 3 acts to stake their claim. Section 29(1) of the Trademarks Act 1999, Section 29(2)(b) of the Trademarks Act 1999, and Section 29(4) of the Trademarks Act 1999. The courts announced that in order for the case to move ahead, Nandos had to prove a few things. That the mark of the defendants, Nandos, was similar to the plaintiff's mark, Nandos. That the defendant's services of running restaurants, food outlets, and goods like sauces, condiments was similar to the goods sold by the plaintiff registered under its trademark Nandu for the processed or frozen meat products. That such similarity was likely to cause the public to confuse or associate the defendant's mark with that of the plaintiffs. Nandos had to establish that because the two were selling similar products, it was likely that a consumer might be confused between the two and pick up something they wouldn't want to. Like when you pick up a capsico instead of a Tabasco. But the courts weren't too taken in by this claim. They pointed out that Nandos is not in the business of selling frozen foods, the way Nandos were, something that both Nandos and Nandos agreed to. This was quite easily quashed. Because of this, the courts waxed on the difference between goods versus services and goods versus goods, which eventually became the basis of their final judgment and a landmark dialogue for IP law and trademark disputes. Nandos provided a good, frozen meats. Nandos, on the other hand, provided catering service. You couldn't just walk into your local kirana and buy a Nandos product the way you could buy a Nandos one. And nor could you go to your nearest Nandos restaurant because, well, it did not exist. Unlike a Nandos restaurant, which did very much exist. There's an example from the past that could throw someone into confusion. The Madras High Court had to deal with the issue of a Health and Glow, a product that sold cosmetics, and another Health and Glow that provided hair care services. Unlike in our case, however, the courts did believe there were grounds for infringement. The trademark law is not intended to protect a person who deliberately sets out to take benefit of somebody else's reputation with reference to goods, especially so when the reputation extends worldwide. With no proof that Nandos deliberately rubbed their hands and schemed to mimic Nando's trademark, and the fact that Nandos had a worldwide reputation that did not require them to do such a thing, the courts ruled in the favor of Nandos. So, that was that. Nandos walked free and continued providing a service, while Nandos continued providing their goods. And to this day, nobody has come out to say that they've been confused between the two. The IP and Trademark Acts are some of the most complicated yet interesting courses for any enthusiast to take, and the cases are almost all as strange and absorbing as this one. To learn more, you can pick up the LLM course provided by upGrad, and who knows, you might be defending the next case that turns into a case study.